Thanks, Christy, and thanks everybody for joining us. I know this is a webinar. You can hear me. Of course, I can't see anybody. I'm actually being videotaped on this end, and so I have two people in my room, Jim and Christy, and lots of people. I think we might have up to 150 people that are listening in today. So I appreciate your time today. We're going to talk about some new rules that came into being a couple years ago, but are still so new that there's I don't think really any case law that's come down on these new rules yet, but we do have the prior rules for some guidance, but there's a lot of new stuff that came under these rules. So I appreciate Christy giving me a little background. I am the chair of our construction law practice group. I spend most of my time handling construction law matters for our clients, and I represent I think everybody on the chain. So I've got owners, I've got architects and engineers, I've got contractors, subs, suppliers, insurance companies, and sureties. And so I think I've seen many of these issues from different angles, and so I think that background might be helpful today as we're looking through a few things. I am also part of the construction law section for the Bar Association, and I'm one of the founding members of that. We've only been around for just a little bit of time. But that's a little bit of background on what I do. But today we're going to talk about mechanics liens. The purpose of a mechanics lien is to provide a way for people to get paid on projects where they've benefited the property. It is something that raises a lot of questions. It is a statutory remedy, and it's one that you must follow the statutes exactly to have rights. It is not something that was available at common law. Subcontractors at common law who didn't get paid were not going to get paid unless they sued the party who hired them, the general contractor, and could get recovery that way. Many times, as we know, the general contractors, unfortunately, might go out of business or might not have the money to pay. And the legislature decided a number of years back that a proper way to handle this is to create these liens. But the downfall is you do have to follow the statutes exactly. The lien laws vary by state, and the thing to keep in mind is if you're practicing on some border towns, Sioux City, Davenport, Dubuque, where you have clients who might cross over into another state, you need to check out the rules in that state, because that state, those rules, although they might be fairly similar, there are a lot of differences amongst the states. Especially when it comes to notices and time periods and things you need to do. So my presentation today is limited to Iowa only. So if you have questions about other states, we will have to look at their rules. In Iowa, you will find those rules in Iowa Code Chapter 572. That is where the mechanics lien rules are. But one other thing you might want to check, and I'll point this out as a part of these new statutes, the Secretary of State's office serves as the administrator, and the administrator has the ability to make their own rules. So one other place you might want to look is Iowa Administrative Code. It's under 721 and then Chapter 45 of 721. So there are some rules that deal with this database specifically right there. So I would have you take a look at that as well. But let's talk about these new rules. They passed in 2012 when the legislature of 2012 was meeting. The two House files that they came out of were House File 675 and House File 2465. Now, I understand you can look those up if you want to, but the reality is those have all been adopted into the new 572. So they're all, whatever was in those House files is into the bills that got passed and signed by the governor. Now, how did we get there? How did we decide we needed to make some changes? Well, for a number of years, bankers, I'll call them title opinion lawyers, and the Secretary of State's office all talked about having the need for a central location to find things. It was a part of doing transactions with real property and trying to find where liens were. And they were all over the place. And some properties and some borrowers, you might have to look in different counties for where some of their assets were, and it was causing some difficulties for them in making their title opinions. and in closing on certain transactions. So they pushed, in the Secretary of State's office, Matt Schultz was the Secretary of State at the time, he stepped in and said, we can house this at the Secretary of State's office. They already do centralized filings for a number of corporate documents, and this was something they said they could handle. So the Secretary of State's office stepped forward and helped push this bill through the legislature. They worked with the bankers and the title lawyers and the Bar Association. Actually, at the time, that was right around the time where the construction law section was coming into being. And they asked our opinion on what we thought of these laws and whether they should pass. And we studied it and we looked at other states, and the laws that passed in Iowa were based on some laws and a database registry that the state of Utah had been using. And we looked into it, and we talked to a number of lawyers in Utah and talked to a number of people who were using the system and heard of a number of problems with it. So the recommendation that came from the Construction Law Committee was that we shouldn't pass these new laws. Well, as you can see, our weight doesn't carry very much, and the laws passed and they came into being. And these new laws apply to any labor performed or materials furnished to a site after January 1st, 2013. Now, the good part about us knowing the issues that were going on in Utah was that we could tell that to the people involved, and they tried to make some changes to what Iowa was going to adopt. In particular, the biggest problems the state of Utah was facing was with their online database, their web page, their web system that they used to file everything. And they were having significant problems with that. The Secretary of State and his office, when they were designing the database, looked into those and tried to design Iowa's system so that it wouldn't have the same problems as the state of Utah. And a couple years later, this new system that Iowa has seems to be working pretty well. We don't have some of the glitches that they were having in Utah, and so it's been a successful transition to an online system. Now, the big thing about the rules to keep in mind is that they generally apply to residential construction, not commercial construction. That's a distinction that was made clear in the rules, and some of the parties who were lobbying for the bill got the exclusion of commercial construction. So for the most part, they apply to residential construction. That is a definition that I've included for you here, and it means construction of single-family or two-family dwellings occupied or used or intended to be occupied or used primarily for residential purposes, and includes real property pursuant to Chapter 499B. 499B is the Horizontal Property Act that talks about apartments and condominiums. So as a big picture, the rules took effect on January 1st of 2013. For the most part, that's going to apply to just about any project that is out there. Because 2 years later, there's very few projects that take that long to get constructed. Something that might not, these rules might not apply to would be something like a school project that was phased in, where they have to do the work in the summer when the students are not there, or do it over winter. So that might be a situation where you would see that these rules are not going to apply. But I think that's a very rare situation. Otherwise, almost every construction project in the state, private projects, of course, public projects are governed by Chapter 573, which can be a whole nother webinar someday to talk about that. But otherwise, these rules are going to apply to everything that you see.
Brian, we have a question.
Oh, we have a question. Okay. Let me click on my button. Where's your question?
Where it looks like a little question mark.
Oh, I see it.
There you go.
Okay.
Looks like lots more.
Yep, I see the question, and the question is, why are contractors who aren't using subs required to file a notice of commencement before they file their lien? I might try to address this when we get to the section on notice of commencement, and because we're gonna flow right into that. So I'll try to remember this question and bring it up when we get to that section. I see another question about apartment complex under construction. It doesn't matter if, it just matters when the project starts. And so if the project starts today and it qualifies as residential construction, then the rules are going to apply to it. So that was a question that someone had submitted. But let's take a step back and we'll get into each of these items, the notices of commencement. Those are some of the things that changed. So what were the major changes? Well, we had some new definitions. One of those is something called an owner-builder, and that's what you would expect. That's, think of a spec home where an owner builds it for himself and then intends on selling that to someone else. We had the definition of residential property that we went through, and there are others. But another major change was how parties would perfect their liens. How they would do that has now changed. We'll use this database that I'll talk about. There are new notice requirements for different parties, and there are new ways to file. There was the biggest change and the biggest thing that came about from the changes in the law was that a thing called a mechanics notice and lien registry was created. And this is what I refer to as the database because that's what everybody referred to it at the time that it was being put together. So let's talk about what is the database because that's the biggest change. But and that's the biggest part of what these rules focus on. It is a centralized online database managed by the Secretary of State's office. Well, what does that mean? That means it's a website. It's a web-driven system. And before, where everybody would file their liens in each county, we now have, so giving you 99 counties where things could be filed, we now have one centralized location where people can look to see if liens have been filed and to see if certain notices have been filed. So liens are no longer filed in district court. The district courts do not need to deal with these cases anymore. Instead, those are posted to the database, all notices and liens. And you can find that database at the website I've given you, www.sos.iowa.gov/MNLR. The MNLR is Mechanics Notice and Lien Registry. So what are the new requirements? Well, now all parties must use that database. This is not something that you can opt out of. It is mandatory. You must use the database. All of the notices we'll talk about here must be posted to the database. All liens must be posted to the database. And you can't post a lien unless you've posted the required notices. We'll walk through that in detail here in a second. The biggest change from before to now is that if you fail to follow either posting of certain notices or posting of your liens, it will defeat your lien rights. Before there was a question and there was a lot of leeway given to courts to allow late filed liens or liens that weren't technically in compliance with the statute. But the way the new rules are written, if you do not post a notice, it specifically says you will lose your lien rights. And as we'll see here as we go through it, there are certain time periods as to when items need to be posted. And if you miss them, you are out. So let's talk about these notices, these new notices that were created and now required by the new rules. The first new notice is something called an owner notice. And this is a notice, again, required only on residential properties, but it's a notice given to the owner. And the notice needs to be provided in boldface, 10-point or larger font. That's what the statute says. And it needs to say what I have listed here, which is persons or companies furnishing labor or materials for the improvement of real property may enforce a lien upon the improved property if they are not paid for their contributions, even if the parties have no direct contractual relationship with the owner. The Mechanics Notice and Lien Registry provides a listing of all persons or companies furnishing labor or materials who have posted a lien or who may post a lien upon the improved property. Now, the purpose of this notice is to put the owner on notice that things called mechanics liens could be filed. And it tells them where to look. It directs them to the Mechanics Notice and Lien Registry, what I call the database. Now, this notice is something that's provided to the owner but isn't posted. It's something that the statute doesn't say how it must be provided, whether that's by mail or something else. My suggestion and my advice to you is to make sure that your clients, who are contractors building homes for people, include this language in their form contracts so that it's automatically in there, and you can point to that directly by showing a court the provision of the contract that has this notice in it. If you don't have a client who does that, mail will work. I would suggest some sort of mailing that gets you a receipt that shows it's been delivered or somehow otherwise tracked. This notice also has to include the internet website, the toll-free phone number. And again, the purpose of this is many times homeowners are not sophisticated. In fact, our courts have said that they're not very sophisticated. There are some cases, including Speight, S-P-E-I-G-H-T, versus Walters. It's a case that I handled, and it talked about implied warranties. And the courts in that case said a subsequent homeowner is entitled to enforce an implied warranty given from a builder. And the focus of that case was on the fact that the homeowner is not very sophisticated. So that was in 2007, 2008. By the time these rules get considered in 2012, some of that is being discussed by legislators, that homeowners are not very sophisticated. So this first step, and the first thing that's required, this new notice, is to get them so that they are a little more sophisticated. And that is, show them with this notice where they can look. Talk to them about liens so that they know up front there might be some liens. This way, the homeowner can try to take steps to make sure those subcontractors are paid. They can get lien waivers, and they can take other steps to try to protect their property from a mechanics lien. Now, this is one of those owner notices that if it's not provided, the statute says you forfeit your lien rights. So for all the builders out there, it's a big issue, and it's something you need to have and need to include. This notice requirement started on January 1st, 2013, and continues to today. So it is something that needs to be provided, or you're going to lose your lien rights. A second new notice is a notice of commencement of work. And it generally means what it says. It's a notice saying we are starting work on this particular project. This must be posted to the database. There's a form, and you fill it out online, and we'll get into that here a little bit later, that gets filed and posted to the website so that everybody can see it and see when it started. Now, this must be posted within 10 days of commencement of work. If it doesn't, then you can lose your lien rights. Now, this is filed by the general contractor or an owner builder. This notice, though, does not need to be mailed to an owner builder, because the theory there is the owner builder is building it for himself, so they already know that people can file mechanics, so it's not necessarily required. This notice of commencement of work must contain the items that I've listed here. Some of these come from the statute, and some of these come from the Iowa Administrative Code section that I pointed out to you before. Keep that in mind. You might look at the statute and say, well, where did you get some of these? Well, they came from the rules that were adopted. But this notice of commencement of work must have the name and address of the owner, the name, address, and telephone number of the general contractor or owner builder for that project, the address of the property, or a description of the location of the property if the property cannot be reasonably identified by an address. You know, in those situations, think of undeveloped land that they're turning into a new subdevelopment, some new homes in a certain area. They might not actually have the addresses yet of each of those particulars. So that's why this little catch-all is there. D, the legal description that adequately describes the property to be charged. E, the date work commenced. F, the tax parcel identification number. G, the county in which the building, land, or improvements to be charged with the lien is situated. H, the email address of the person posting or submitting the notice of commencement of work, or the email address of another individual or entity designated to receive electronic correspondence on behalf of this person, and I, any other information prescribed by the administrator pursuant to the rule. I will tell you that I've already captured in my description here all of the things that the administrator so far has included or stated needs to be included in this notice of commencement. I think one of the first things you'll see here are they ask for certain specific items, like a tax parcel identification number. And you might be saying, well, where do I get that? Well, this is where it gets a little complicated. Sometimes those are available, sometimes they're not. This is going to require some searching on your part. You're going to have to dig into some records and try and find that. You're going to have to work with your local, your county recorders, an assessor's office, and other governmental people to try to find this information. It's something that gets uploaded to the system as you are posting your notice of commencement of work. There are places where you can find this. Frankly, most of this information can be found online. Most of the recorder's offices, assessor's offices, or somebody in each county, you can find a lot of this information online. If you can't, abstracting companies are helpful to help find this stuff as well. So this must be posted to the database within 10 days. If you don't, you can lose your lien rights. This also must be sent to the owner's address as posted to the database. So you're going to mail it. And if the owner's address on the database is different than the property address of where the work is being done, you also must mail it to that property address. So again, the point of the first notice that we talked about, that I'll click back to, the owner notice, was to put the owner on notice that there might be liens. The second notice is the same thing. Listen, we're getting started. Here's some people. Here's the notice of commencement of work. We've got people coming onto this project. Again, it notifies the owner that work is starting and liens may be something that could get filed. It tells them some specific information about who's doing what, and they can track that better as an owner. It gets mailed to them, and it's posted. So if they look online, they'll see it. If they check their mail, they'll see it. If their home address is different than the property address, they might get it there too. So you'll see my comments that if it isn't provided, the general contractor is not entitled to file a lien, but an owner builder doesn't matter because he's given the notice to himself. So it doesn't seem to apply to the owner builders. If, and as we'll see later when we talk about subcontractors, if a general contractor doesn't file this, a sub can file it for them, and the sub will maintain the sub's lien rights even though the general will lose his or her lien rights.
We have a couple more questions.
Do we? Thanks, Christy. For everybody's benefit in your office, some of this shows up on my screen, some of it doesn't. So one of the questions is, when does this notice have to be given? And that has to be given within 10 days of starting work on the project. So one of the things you list in the notice is when you started, so you can check when you start versus when you post the notice. So it's 10 days. Seems to be that there might be a sound issue here too. That doesn't seem to be. Okay, it seems to be working. So here we go. So the next question, okay, looks like they can hear now. When does the owner notice have to be given? The first new owner notice, that needs to be given, that's the first notice, not the second one. That needs to be given prior to starting work. So there's no set time period on exactly when. Again, our preferred preference to that is that you give it at the same time as you are signing your contract with the owner. That way you have it in writing, it's clear to everybody that it's out there. So we had our first notice, the owner notice that we talked about. We have our second notice, the notice of commencement of work. Then what happens after you file the commencement of work? There's a commencement of work owner notice that the Secretary of State also sends to the property owner. And this goes out automatically. Once the notice of commencement of work is posted to the database, the Secretary of State will assign a mechanics notice and lien registry number to that. So I know someone asked me a question the other day about where do you get your number? Well, it's automatically assigned by the Secretary of State's office when things are posted. So that's where the number comes from. And when that notice of commencement of work is posted, the Secretary of State notes that, puts that on their system, and sends another notice to the owner. Again, we're bending over backwards here for these unsophisticated owners to tell them what's going on with their property so that they can prepare themselves accordingly for potential liens. Now, the notice that goes from the Secretary of State to the owner says what I have here. And again, they're notifying the owner that liens may be filed. This is similar to the first owner notice that was sent out. And this notice from the Secretary of State says, persons or companies furnishing labor or materials for the improvement of real property may enforce a lien upon the improved property if they are not paid for their contributions, even if the parties have no direct contractual relationship with the owner. The Mechanics Notice and Lien Registry Internet site provides a listing of all persons or companies furnishing labor or materials who have posted a lien or who may post a lien upon the improved property. If the person or company has posted its notice or lien to the Mechanics Notice and Lien Registry Internet site, you may be required to pay the person or company even if you have paid the general contractor the full amount due. Therefore, check the Mechanics Notice and Lien Registry Internet site for information about the property, including persons or companies furnishing labor or materials before paying your general contractor. In addition, when making payment to your general contractor, it's important to obtain lien waivers from your general contractor and from persons or companies registered as furnishing labor or materials to your property. The information in the Mechanics Notice and Lien Registry is posted on the internet site of the Mechanics Notice and Lien Registry. The notice by rule was also required to list the website and toll-free phone number. At this point, the owners received 3 different notices. This one specifically tells them about that liens can be filed and that they should get lien waivers. By the time you get to court to try to enforce one of these, the point of these notices is to get beyond the arguments that I didn't know that this could happen. To me, it's virtually impossible if these notices are sent to an unsophisticated homeowner that a court would say they don't know what would happen. And that was the point of requiring these new notices, is to try to get away from some of these arguments that were coming up in these foreclosure suits. So that's the next notice that goes to the homeowner. Okay, the rules also require that a third notice be sent. This is a preliminary notice from the subs, and this is a third notice that comes from the contractor side, the people working on the project. Obviously, the Secretary of State is sending its own notices. But this is a third new notice that's specifically required in the rules. This is called a preliminary notice, and it's posted by subs. Again, it's just for residential properties. We'll talk about commercial properties in a little bit. But the subs must post this on the registry or the database, whatever you want to call it. And this notice cannot be posted until after the notice of commencement of work has been posted. So there's an order in which this happens. If the general contractor or the owner builder didn't post the notice of commencement of work, then the sub can post it for them. Now, if the general didn't do that, the general is going to lose out on their lien rights. The sub can maintain their lien rights, though, by posting that notice of commencement of work for the general. Once that's posted, then they can post their preliminary notice. There's no time period on when this preliminary notice has to be posted, but it has to be done before the balance due is paid to the general contractor or the owner builder. If you recall from Chapter 572, there are some provisions that talk about late filed liens or liens filed maybe after the 90-day period. By the way, the 90-day period from before remains under the new rules. You got 90 days after your last performance of work or supplying of materials to post your lien. That still remains. But in the old days, there was deference given to late filed liens, and courts could consider those. It got up to the point of whether the balance due had been paid. And so here, this incorporates that as long as the sub gets their stuff filed within the time periods and there's a balance due, they can enforce their lien to the amount of that balance due. Now, this preliminary notice filed or posted by the subs, I'm sorry I keep saying filed, it's posted by the subs to the database, must include the items I've listed. First, the name of the owner. Second, the mechanics notice and lien registry number. And that is something they will get off of the website. It will already be on there. They get that when the notice of commencement of work is created. Third, the name, address, and telephone number of the subcontractor furnishing labor, service, equipment, or material. 4, the name and address of the person who contracted with the claimant for the furnishing of the labor, service, equipment, or material. 5, the name of the general contractor or owner builder under which the claimant is performing or will perform the work. 6, the address of the property or a description of the location of the property if the property cannot be reasonably identified by an address. 7, legal description that adequately describes the property to be charged with the lien. 8, date the material or materials were first furnished or the labor was first performed. That's tracking the language we've always had in 572. 9, the tax parcel identification number. 10, the county in which the building, land, or improvement to be charged with the lien is situated. 11, the email address of the subcontractor or the email address of another individual or entity designated to receive electronic correspondence on behalf of the sub. And 12, any other information required by the administrator. Again, I've already looked at the administrator's rules under the Iowa Administrative Code and included those for you in here. But you should check that to see if anything changes. But those are what are required. Again, this is giving information to the owner so they can determine who's working on their job, what they're doing, who they're working for, when they started. And that's all done so that the owner can try to account for them and get lien waivers so we don't have to deal with mechanics lien claims. When this preliminary notice is posted, the Secretary of State mails another owner notice to the owner's address. The Secretary of State also posts proof of service on the registry of when these items were posted. So everybody can track it. It's automatically done. When you go to the web registry and search, you will see the date and time that gets stamped on when everything has been posted. Now, it becomes important on the proof of service and the other items because if you ever get to a situation where that sub is foreclosing on his lien and trying to enforce its lien rights, that sub, by statute now, has to prove by a preponderance of the evidence that the owner received the required notice. So they can do this by separately providing the notice to the owner by certified mail, a personal service, or some sort of actual notice by getting a signed receipt from the owner. I would bend over backwards to try to get it as many ways as you can just to make sure it's been done. Similarly, like the other notices, if a sub doesn't file this preliminary notice, then they shall not be entitled to the lien. That's exactly what it says in the code, and that's what happens. Just checking to see if there are questions. Yeah, there's a good point being made here that the database and these filing requirements not only benefit homeowners, but also protect subs by making sure that the closing agent knows who to obtain lien waivers from. That's a good point. Thanks, Tim. In addition, it protects lenders by allowing them to know with certainty they have a first position mortgage. Those are all good points. Thanks, Tim. So those are the new notices that are required. So what else is new? Well, we have a whole new way of doing things. Again, we have to post things. So what's the first thing you have to post when posting a lien? Well, it's the same thing you had to post before or file before. It was a verified statement of account. And the code says that you must post a verified statement of account of the demand due the person after allowing all credits. It must be verified, so it has to be signed by somebody. There's an open question on whether that needs to be signed by the client or whether the lawyer can sign on behalf of the client. My preference is always to have the client sign for fear of making yourself a witness if you sign. So my practice is always to get my client to file those or to verify any statement of account that may get posted. But the statement of account has to be verified and include the items I've listed. The date when the material was first furnished or labor first performed, and the date on which the last of the material was furnished or the last of the labor was performed. Second, the legal description of the property. Third, the name and last mailing address of the owner of the property. Fourth, the address of the property or a description of the location of the property if the property can't be reasonably identified by an address, and the tax parcel identification number. What you'll see is many of these items are what were included on the old bar forms that we have. In fact, most of the time what I see people do is they fill out the online form that you upload information to it, and you attach to that a PDF document. And what I've seen most people attach, and frankly what I attach, my form is just the old bar form. And I've added a couple pieces of information that weren't on the old bar form, like the tax parcel identification number. I have my clients sign those. And that is what I post as the verified statement of account. I would suggest you guys might follow the same pattern. You might have your own way of doing it, but make sure it's verified and make sure something's attached to it. If you don't post something to the uploaded form, you risk an argument being made that you haven't properly followed the procedures. The form is just a form. It's not the verified statement of account. And you'll see when you get on the database that they ask if you want to upload something with your form. That's where I do mine. The lien is limited to the county in which the building is situated, and the county identified on the database shall be the only county in which the building may be charged with a mechanics lien. This is something that could create a problem for you. And why I say it could is there are some construction projects that go across county lines. In those situations, you might have to pick which county you file it in, and you might have to just file it in 2 different counties and file 2 different liens to protect yourself. That's what I've done in the past. And the way the system works is you can actually file 2 different liens. It won't be one lien that covers both counties, because you can only have 1 county on 1 lien. So I'll file 2 liens and cover both. There are some, I think Eddyville might be the strangest town in Iowa. I think it actually covers 3 different counties. And I know I've had some projects over in that neck of the woods where you really have a question as to which county you're in, and you have to check that. Sometimes with GPS to figure out exactly where you're going. But the statement of account is not new. It's something we had before. There might be a few things new that you have to add to it. So here's a question that came up is, well, what happens if you're on commercial property? Because up to this point, we've really talked about residential. All the new notices deal with residential property only, not commercial. Commercial properties, though, you're still going to have to follow the posting requirements and still have to use the database. But what would you have to do to post a lien if you're working on a commercial property? You won't have to deal with these notices, but how do you still post your lien? Well, the first thing you have to do is register as a user on the database. This is very simple. It is something that you fill out online, and it just uploads your information, so you become a user. But in addition to the requirements on the slide before, and I'll go back to it, about posting a lien, the A through E items that I've listed there, if you're on a commercial property, you also have to add these new items, A through D. And these include the name and address of the owner, the name and address of the general contractor or owner builder, the county, and the email address of the person posting or submitting this. This information is required on a commercial project because we're not filing some of those prior notices that you have on a residential project. You can find all that information by looking at the prior postings. On a commercial job, you won't. This becomes important because each of these items becomes an item in which you can search the database for things. So you can go on the database and search if you have the mechanics lien or mechanics notice and lien registry number, if you have the property owner's name, if you have the property address, each of these items becomes a way to do a search and try and find what has been posted. So let's say we get to the point, whether it's a residential job or commercial job, what happens after a lien gets posted? That's the next logical question. The notices are all filed. Everybody does what they're supposed to do. Well, what happens? Well, the Secretary of State, the administrator, then will file, serve a copy of the lien upon the owner. The owner will get it that way. The owner's notice here saying a lien has been filed will refer them back again to the database with the website address and the phone number. One thing to keep in mind is the minute you post something to the database, it's searchable and findable by anyone. So if I file at midnight, everyone in the world can find that by doing a search. It's automatic, and there's no time delay between posting and some kind of acceptance. It's automatically done. This is somewhat like federal court. When you file something electronically, it automatically pops up and everybody can see it. In state court, under Iowa's filing, the judge has to accept things, or the clerk has to click the button to accept things before anyone can see it or get notice of it. Here, this system is automatic. The minute it's filed, you can see it. The liens posted have to include the items I list here, A through G. And the reason, again, those are needed is because those are some of the ways you can search the database to find records for different people. So if you list the name of the person who posted it, the hour of posting, the amount of that, the name of the person against whom the lien is posted, legal description, tax parcel identification, and the address, those are all ways to search. And it also shows who's filing what when. Every time something is posted, there's an electronic file stamp put on it, so everybody can see when that was done. Keep in mind, it's free access. You don't have to pay. It's not a subscription service. Anybody can look whenever they want. In fact, when you pull it up on the Secretary of State's webpage, that's the first one. The first box you can look at says search. So we talked about notices. We talked about posting of liens. The next step, or the next item that people might ask about is what's the priority of liens? This is a little bit different than what we had before. Priority of liens is determined by the time those liens were posted to the website. So if I post mine now, you post yours 5 minutes from now, my priority will come ahead of yours. This is somewhat different than before, where there was some relation back, but the code now says priority is determined on the time of filing. Again, these liens are indexed, the timestamp is put on them. Construction mortgage liens are still preferred to mechanics liens. Basically, if the mortgage was first, it's going to get preferred. If the mortgage comes afterwards, there'll be a question, and usually the lien can win out over that. And that's even if the lien gets filed within its appropriate 90-day period. Okay, so let's have a little how-to. How to use the database. How can I get on it? How can I be a registered user? How can I work through this? Pretty simple. You just have to set up an account with the Secretary of State's office. This is done online. If it takes you 2 minutes, I would be shocked. It should take you about 30 seconds. What they do once you set it up, it works just like Amazon or any online service in which you want to buy something. You upload some information, they create an account for you, gives you a password protected way to get in. You can pay by credit card. That's how most people are signed up, so that when you post things and have to pay fees, they'll automatically put it on your credit card for you. So when you set it up, it's simple things like an email address, name, business name, mailing address, telephone number, and security password. The good part about setting this up is once it's up and you log in as you, the system will automatically upload your information into any filing that you want to perform. So if you're filling out a notice of commencement, and it's going to list you as the person filing it and automatically fill in that form with your information. You'll still have to get the rest, but it makes it go a little bit quicker. Okay, so we go back, we get you registered, we get you in there. We've talked about the notices. We've talked about the different steps you need to do, the posting of the liens. So let's try to boil this down and get it to what must certain people do. Okay, if you're an owner, there's nothing for you to do. It's really simple. These rules are designed for your benefit and designed to try to help you out. So you just take a look at the notices you get, pay attention to who's working on your property, and try to get some lien waivers put in place before you make payment. That's the best way to protect yourself from lien claims, is to have lien waivers signed and given to you before you give out any payments. And get those so that people are waiving their lien rights up to the date of your payment, as well as waiving for the work done that constitutes that payment. That belt and suspenders approach works really well because it prevents lien claimants from coming back later and trying to ask for more money if you use the belt and suspenders approach. If you're a general contractor or an owner builder, you're the next step down. What do you need to do? There are 3 things you need to do to help protect yourself under these new rules. I got these a little bit out of order, but you should provide the owner notice to the owner. That's the first notice we talked about. It's the first thing you need to do. Second thing, post the notice of commencement of work. Got to do these to protect yourself. Again, these are on residential properties. Third, post your lien within 90 days of last work on the job. This is the same rule as before. If you aren't paid, you want to protect yourself and assert your lien claims, you got to get your lien, used to be filed, now it's posted within 90 days of last performing work. So those are the boiled down provisions of what a general contractor should do or an owner builder should do. What must a sub or a supplier do? And by supplier, I mean a first-tier supplier, someone who's supplying things directly to the general contractor, as opposed to what we'll show you here next, a second tier. So it's one layer down from the general contractor or owner builder. First, they should search the database to see if the notice of commencement of work was posted by the general contractor or the owner builder. If it was not, they should post it. That protects the sub's ability to assert their lien rights. Again, if the general or owner builder didn't, they've lost their lien rights. But a sub can maintain his or her by posting that notice. Second, post the preliminary notice that we talked about. That protects the sub in all ways. Again, you can't post that until the notice of commencement of work has been posted for residential jobs. Third, get your lien posted. Do that within 90 days of last work on the job. What must a second tier sub or supplier do? This would be a material supplier. So we have a general contractor at the top. They hire a plumber. The plumber needs to get some parts from the local hardware store or local plumbing supply store. That's the level I'm talking. Somebody who's supplying either materials or work to a sub on a job. Second tier sub or further down the chain. What do they need to do? The rules have not been changed. If you were at that level, you were required under Chapter 572 to send a one-time notice, basically giving notice that you're out there and what you're doing. And this one-time notice still remains a requirement under the new rules. And that notice has to contain the name, mailing address, and telephone number of the person furnishing labor or materials, and the name of the sub to whom the labor or materials was furnished. It has to be done within 30 days of first furnishing labor or materials for which a lien claim may be made. So in my example, the plumbing supply company who's given copper piping to the plumber for a job, they need to get their one-time notice out. Once the one-time notice is out, that's all that's required. If they subsequently supply more materials, the first notice covers that. They don't need to do two. So if they've given the one-time notice, then what do they need to do? Search the database to see if the notice of commencement of work was posted. If not, post one. And then get their lien posted within 90 days of last supplying any work or materials to the job. So if you're in that chain as the owner, the general, sub, or second tier sub or supplier, those are the steps and the bullet points that you should take a look at following. Okay, now the next question. We've talked all day about residential properties and how these rules are really designed for that. What happens if you're on a commercial project? And again, I gave you the definition before, but basically if it's a residential, single family or multifamily to a point, those are residential. Everything else, industrial properties, anything else is considered commercial or non-residential. So this is what you would follow if you're on a commercial job or something else. So regardless of that fact, you still have to post your lien on the database. So what is that going to require? Well, you're going to have to set up an account and post it. Pretty simple. Once you get it down, it's pretty straightforward. The notices of commencement of work, though, are not required on a commercial job. The preliminary notice that we talked about for the subs are not required. The one-time notice for second-tier subs, though, is still required. So make sure that if that's the level that your client falls into, that it protects itself by sending those one-time notices. That law has been around for a long time, and most of those subs already know that that's the case, and they're already complying with that. So that's not going to be a big change for them. It should just be automatic. They should have a form that goes out on every project they're working on. Okay, let's summarize real quick. If you're a residential general contractor or owner-builder, you give a written notice to the owner. You then post a notice of commencement. Subs on that residential job can then post a preliminary notice. And if people aren't paid, at that point they file their liens. That's the summary of this new process that we have and the summary of the new rules. Now I see that we have 5 minutes left. I was going to check to see if we had some questions. Looks like we might have a few. Give me a second to look at these.
And if you want to delete any ones you answered, just hit the little thing that's like a trash can and then go away.
Okay. There's a question on here. It says, when filing the verified statement of account, do you as a practice pointer upload both the old bar form and a bill of particulars or invoices? Yes, that is my practice pointer. That's exactly what I do. So what I post to the registry will look identical to what used to be filed in the district courts. I have the statement of account that they sign. Attached to that, I usually have an Exhibit A and an itemization of getting from $0 up to whatever they're claiming. And depending on how big it is, I have them attach invoices if it's small. It depends on the project and depends on how much people are after. The larger the dollar amount, the harder it is to include all the invoices or backup documents. But I do include on there some sort of itemization getting from 0 to whatever their number is and how they're getting there. So that is something I do on both of those. So that is usually my statement of account. The next question is, what is the benefit to the contractor in these new rules? And they have some clients that wouldn't really know about this information. It wouldn't be public knowledge. Well, the benefit to the contractor in these new rules is that, assuming they follow them and all the notices and things are done, it makes it easier for them, for a contractor, to argue in front of a judge that they should be paid, and it takes away the sympathy arguments, frankly, to an owner who tries to say, well, I'm unsophisticated, I don't know how this works. Well, now they've been given a number of notices, a number of reasons to look into it more, and that argument goes away. So the question then really focuses on, at any foreclosure suit, it focuses on what did you provide, how did it benefit the property, and how much should you be paid. And it really takes a little bit of the emotion out of the situation. Next question, how do you release the mechanics lien? That's something I didn't cover. We only had an hour here today, but there are satisfaction of lien forms that you can file. There are things you can click on the system to file and release any sort of lien that's been satisfied. So that's a simple uploadable form. that you do on the web page. These are clicking through pretty quickly here. Another good question. What are the fatal flaws when posting notices? For example, what is the implication of a misspelled name or notice posted in the name of an individual rather than the individual's LLC? Under the old system, there was some leeway given, and the court cases would say, you know, we're really focused on getting the appropriate person the notice of what's going on. And as long as you get close on some of this stuff, they would let people enforce their liens. The new rules are so new, we don't really have any cases. In fact, I'm not aware of any case that interprets any of these new statutes. They just came into being in 2013. But my belief would be that as long as the owner that you are trying to enforce your lien against has somehow gotten the notice, I think the court's going to give you leeway. The point of all of these items that are required, the tax identification number, the legal description, etc., all those are to get to the proper owner. So if you just say it's Joe Smith owns it, and it turns out it's Joe Smith LLC, I don't see that as being too much of an issue as long as Joe Smith LLC, if they're the real owner, is getting these notices. So I think those same arguments can be made. I think they'll be a little harder to make because all the notices go to who the state believes is the owner of that property, and that's determined by tax records or assessment records or other items. So the next question is, what happens when a sub makes a one-time repair, like a plumber or an electrician? And the question is it unrealistic for them to file a notice or provide notice every time they go to a job? You know, is there an exception for that type of service provider? There's no exceptions for subs based on the work they do or material suppliers based on the work they do. If they're going to be doing a significant amount of work, I would advise them to protect themselves and follow the rules that are required under Chapter 572. If it's a one-time hitter where a repairman goes to somebody's house to fix a couple of light switches, well, the maximum amount of that bill is probably not going to be very much. And, a lot of these decisions on whether you want to go to the time and effort of protecting yourself will probably be based on what's the ultimate bill going to be. And if it's a small amount, I got clients who just don't even bother. If it's a larger amount, then they take the steps required to protect themselves. So that's how I see a lot of those. There was a question here that says, do I agree that notices are not required by statute when the general on a residential project doesn't use subcontractors? Now that is a correct statement. If you look at the statute says a general contractor or owner builder who intends to use subcontractors needs to follow these rules. So if it's just a general building for himself doing all the work, then some of these notices are not going to be required. The theory behind that is that mechanics liens really are not for the benefit of for a general contractor. They're really for the benefit of suppliers and subcontractors. And the reason it's that way is a general contractor who's building for someone always has his contract to fall back on if a lawsuit is necessary. A subcontractor doesn't have privity with the homeowner, and that's why these statutes were really created. But so the protections aren't as necessary for a general contractor with that. But that is correct that you do have to have an intention to use subs before these kick in. Another question. How does it work if an owner-builder sells the property during construction? Any changes to the process? The answer is no. It's a process that is required to be followed, and if the owner-builder doesn't do what they're supposed to do at the time periods they're going to do, they would lose their lien rights, and anyone who would step into their shoes would. But the notice requirements and everything else still flow to that project just like anything else. So a sub who comes and sees that notice of commencement of work hasn't been filed, they should still post it and then post their preliminary notice. So I wouldn't change anything if somehow the owner or owner builder gets changed out on the process. I'm looking at a few more questions here. Some of these we've kind of covered. Another good question. If the statute is missed somehow, can the general or sub still sue in court to recover for the work? Yes, they can. They would have to fall on either a breach of contract or unjust enrichment or some other theory. They won't be able to sue based on their lien and won't be able to use the lien laws to try to enforce that. So that's another good question. Searching through some of these questions, they all look to be about the same, or something that we did cover already. So I guess I'll have last call for questions. If you have them, shoot them in here real quick, and I'll try to address it real quick. I'm kind of going back through. Well, I'm not seeing any. Here's my last slide for you guys. I'm happy to answer any questions you have. I got my email address on there and I've got my phone number. So feel free to call me with any questions you have. In fact, I actually got a call or an email from somebody before we even started. They saw that I was going to give this webinar today, and they already had a question, and I answered it for them. So I appreciate you guys taking the time today. I kept it about 5 minutes after what we were supposed to, but I tried to answer your questions. I hope it's been helpful for you today. Again, if you have any remaining questions, give me a call. Thank you.